Public Service Commission meeting. We have the reading of the meeting minutes of August 8th, 2017 to kick off the meeting with. Are there any changes, modifications, corrections? Yes.
Two things. First and foremost, was this motion carried 5-0?
Which motion are you referring to?
I'm sorry. I'm looking at the regular agenda items. I'm looking at number 4. In the matter of the application of Delaware Power and Light regarding the natural gas, the valve. Sorry, I'm looking at the motion regarding the excess flow valve.
Did you vote abstain on that one?
No, I think that Commissioner Gray abstained on that one. Am I right? Am I wrong?
I'm going to have to defer to the meeting minutes because I don't specifically recall which item.
And I had one more question, and that is that with respect to who pays for the valve, the company will pay for the valve, but the customer will pay for the cost of installing the valve, and so there will be no true-up. However, no expense will go onto the books of the corporation. However, the corporation has purchased the valves, so why is that not an expense? Just the question. Because this is...
I think that my recollection, God bless, is that the actual piece of equipment is purchased by the company and becomes part, I guess, of the rate base. And then the customer pays for the installation, and then afterwards, that's it.
So is the valve an asset of the corporation?
Yes. It's owned by the corporation.
Just one minor question for clarification. So I understand no expense will go onto the books of the corporation, but it would seem to me that the asset value of the valves is going to be on the balance sheet. Is that a good statement?
That's correct. When I made the statement about it's post-installation, there will be no...
Yes, that's clear. Okay.
Thank you.
Well, then I would question in the minutes, is this an accurate statement? There will be no expense going onto the books of the corporation as a result of the installation.
Just the valve. Yeah.
But it doesn't say just a valve here. That's what I'm asking for clarification. Is that an accurate enough statement?
Well,
It says as a result of the installation.
Not the purchase
Not
of the
the
valve.
purchase of the valve. It doesn't mention the valve.
No
It's
further
just
questions.
the installation.
No further questions.
Thank you. Chair, I'll move that the commission adopt the minutes.
I second it.
is there any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. The consent agenda. Does any commissioner wish any item on the consent agenda to come off and be placed on the regular agenda?
Move we adopt the consent agenda as presented.
A second?
Any discussion on the motion to approve the consent agenda as presented? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Regular agenda, number 1. In the matter of the application of Delaware Utilities, Inc. for a CPCN. We've got Ms. Higgins.
Good afternoon.
Welcome.
Thank you. Good afternoon. We have a CPCN before you in our Rehoboth district, and it's on the regular agenda because 2 of the 4 copies to the regulatory agencies did not reach their intended location in the time frame. So we had to ask for a waiver for timing, and those 2 agencies, the State Fire Marshal's Office and the Office of Drinking Water, did in fact receive them just a few weeks late. We are in agreement with the order.
Mr. Willard.
Yes, exactly as she said, and also those 2 agencies did respond and say they had no problem with this at all. So the staff recommends that you do grant the waiver.
Ms. Iori?
The public advocate was not involved in this matter.
I just like calling your name
It's so melodic, isn't it?
and hearing your voice.
It's not so melodic.
Are there any questions from the commissioners?
Move we adopt order number 9099.
I second.
Any discussion on the motion to approve proposed order 9099? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Ms. Higgins. Mr. Willard. Number 2, in the matter of the application of Chesapeake Utilities Corporation for approval of a change in its gas sales service rates. And we should have Mr. O'Brien.
Thank you, Chair, members of the Commission. Bill O'Brien. What you have before you is proposed order number 9103 that the company has reviewed and urges your approval thereof. This is on Chesapeake's request to waive a section of its tariff that requires the company to file a new GSR rate when its over-under collection on its gas sales service rate goes over or under a certain band. The under band is at 6%. That triggers a filing. We did go below 6% on the under collection, mostly because of the warm weather we had last winter. But it did build up over time. We made this request because there's so little time left in the GSR period that there'd be barely a dent made in the under collection if we did make this filing. And the filing itself is essentially another GSR filing, so it does require a lot of work by staff, and if the public advocate participates by the public advocate. So this would simply roll that under collection into the case that we're going to file actually in the next couple of weeks. But it would mean that we didn't have to do this interim filing.
Thank you, Mr. O'Brien. Mr. Walsh?
Thank you, Chair Winslow and Commissioners. Mr. O'Brien's recitation is accurate. We did review the request and the calculations and supporting documentations, found that they were mathematically accurate, and I think this is warrants approval. It's certainly a better use of resources to allow the September 1st filing to go ahead and not force this section of the tariff to be imposed with this short time frame and no real benefit from it.
Thank you, Mr. Walsh. Commissioners, any questions?
Yes, Mr. Chair. I would make a motion that the Commission adopt order number 9103 as submitted.
I second.
Yes, I have a comment, Mr. Chair. If I look on the staff memo as well as the order on page 2, I'm noting that the under collection is a result of below normal weather, and I would question, is that instead because of above normal winter temperatures? It's reflected here as below normal weather conditions? Does that imply above normal winter temperatures?
If you're asking me, Commissioner Gray, I think your language would probably be more understandable. When we
Okay.
read this from staff's draft, we read it as weather below the extremes that are usually experienced in the winter.
Okay.
But
Well,
above normal temperatures is accurate.
I might recommend that it's a little clearer in that context. But otherwise, I have no further comments to the motion, Mr. Chair.
Hearing no further comments, all those in favor of the motion signify aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Mr. O'Brien.
Thank you.
Number 3 is in the matter of the petition of Artesian Water Company to establish a regulatory asset. The staff's petition for rehearing and reconsideration. You know, it's funny how you find yourself in different places. And I was coming up from the Lewis today in my Jeep, and I had the music up pretty loud, and the wind was blowing through my hair. I'm singing to the radio, and all of a sudden, the record comes on and goes, how's it go? I will stand up, I will not back down. Came on, I said, well, that sounds like a Regina and Jim Geddes song.
Now, let's not get personal.
Then the next song on was I Fought the Law and the Law Won. So we're going to find out. Who was singing that second song.
I don't think Mr. Geddes is involved in this one, though. So.
I brought my popcorn and my special eclipse glasses.
But he's a target we like to pick on occasion.
Would you like to pronounce my name too?
Dennis,
Also
okay.
melodic.
Chair Winslow, I believe that those artists would be Tom Petty and originally Mr. Gene, also done by The Clash and The Who, respectively. But
Well, I appreciate that, Mr. Walsh. Just don't bring out your guitar. And I was on the Petty Sirius station, so yeah. So okay, so we could hear from Mr. Walsh, I guess, to kick this thing off.
thank you, Chair Winslow and Commissioners. Again, this is staff's motion for rehearing and reconsideration of order number 9031 in docket 16-0008, which was the emblem formal complaint against Artesian Water. This ultimately resulted in a hearing, evidentiary hearing before the Commission on December 20th, and the Commission approved in this docket, 16-010, I'm sorry, in the previous docket, we opened this docket to reconsider order number 9039, which was entered March 28, 2017. I would like to, if I may, pass the baton to Ms. McDowell, who was been chomping at the bit to get to the legal bases for the Commission's rehearing of this matter.
Ms. McDowell.
Thank you. Although the DPA argues that this matter should not be heard because staff and Artesian could have delayed this matter and given staff time to better prepare, since we only have a day to respond to her response before that commission meeting. Staff believes that the commission would be remiss if they didn't hear how regulatory asset treatment had been handled previously by the commission. So the commission has regulatory reg assets in a variety of ways. The legislature has required the commission to set up reg assets. This is in the efficiency energy projects that you will soon be before you. Dynamic pricing and direct load control. The commission has also directed Artesian and then United Water, which is now Suez, to set up reg assets when they participated in the Chester Water Authority rate cases. That was to help control rates going up to their customers for the purchased water that they need. Delmarva and Chesapeake have environmental cleanup costs. They did meet the extraordinary expense and the financial integrity criteria. Also, the commission has deferred capacity costs of Chesapeake to the next GCR case. There was no financial integrity to Chesapeake in those cases. It was like $275,000.
I'm sorry, Ms. McDowell, could you repeat that about the Chesapeake case?
They have deferred capacity costs back in 2007 and 8, which was then approved and forwarded to the next GCR case. But there was no basis explained, and so there was really no financial integrity because it was $275,000. The Commission has also approved AMI and reprogramming of billing system costs. These are long-term projects and they do have financial integrity. We've had other cases where the Commission has to approve extraordinary expenses and that it met FASB 71 and that future revenues matched those future expenses. And that's the basis of staff's argument in the Artesian emblem case. The DPA only told you a few ways that led you to conclude that Artesian's requests did not meet the criteria of extraordinary expense and financial integrity. And in the Artesian case, staff felt that it was very important because Artesian stepped up to the fight for its customers. The DPA did not participate in the complaint docket. If Emblem did not pay the SIAC, then the customers, future customers, would have seen those costs in future rate cases. Also, if Emblem won, you'd have all the other developers not paying SIAC, and this would mean that the customers would have to be bearing the cost of any future expansions. The DPA also argues in the response that the return on equity set by the Commission covers the risk taken by the utility for matters such as this. However, return on equity is what investors require to invest in the utility stock. If the stockholders have to cover such costs as these legal costs, they'd expect a higher return on equity, which would again increase rates. So the staff is requesting that the Commission reconsider their position in this docket, and we're concerned that there's precedent set dealing with that the criteria is extraordinary expense and financial integrity, and consider that on a case-by-case basis. Thank you.
Thank you, Ms. McDowell. Mr. Randall?
Good afternoon. On behalf of Artesian, we support staff's motion for re-argument. The starting point for me is there appears to be a basis for re-argument. When we address the standard for granting regulatory asset treatment in December, the argument centered on what the DPA had proposed was the legal standard, which was apparently three-pronged. The expenses had to be extraordinary, it had to threaten the financial integrity of the utility, and it had to or impair the utility's ability to provide safe and adequate water service. And while there was perhaps some belief that the expenses were extraordinary because we had incurred them to protect our ratepayers, we were not able to show that it threatened the financial integrity of our company, and the expenses did not impair our ability to provide safe and reliable water service. That ended up being reflected in the order that was entered as the primary basis why the petition was denied. We credit staff for researching what the Commission has done with respect to regulatory assets for other utilities. Staff was able to find 5 examples where apparently a different legal standard had been applied to allow a regulatory asset treatment. Those were not proceedings where utility was a party, and frankly, we were not aware that they existed. Apparently, staff and the DPA should have. Again, there was some unfortunate timing involved here where a written brief was submitted the day before argument. To touch on that briefly, Artesian believed that it had to proceed with argument on December 20th. That was when the emblem proceeding itself was scheduled for a final resolution. the parties had stipulated that there would be no appeal. So the decision of the emblem proceeding occurred December 20th with no appeal. In our last rate case, where we sought recovery of legal expenses, one of the bases that they were challenged was that it would have been retroactive rate making. All of the expense for that issue had been incurred in the past. You cannot allow recovery in that circumstance in the future. If the decision on regulatory asset treatment occurred after the decision in the underlying proceeding, we believe we would have been susceptible to we would have been barred as a matter of law, that it would have been retroactive rate making to grant us that relief. It had to be decided December 20th. It was unfortunate that we did not have more time to respond. We felt we needed to go forward. Staff subsequently found these other precedents where a different legal standard applied, one of which was just a settlement. It wasn't based on a statute or anything else. The bottom line is this commission has the discretion to decide under FASB 71 when it is appropriate to give deferred regulatory asset treatment. The only other point I would like to make is granting the deferred regulatory asset treatment would only be step one. It does not mean that Artesian would actually recover the dollar-for-dollar expense. That would simply mean that in our next rate case, we would have an opportunity to seek recovery of that, which may be granted or denied, based upon whether this commission believed it would be just and reasonable to allow that recovery. We have heard the commission and what it said at the last hearing in December, but we believe for policy reasons, it would be important to assess whether in the circumstance of a utility that seeks to protect its ratepayers, you want to at least incentivize doing so by creating the regulatory asset. Then, at a later date, you can decide whether that money actually gets recovered. So for those reasons, we thank staff for finding precedents which Artesian would not have been aware of. We believe that you know yourselves whether your decisions in December were based upon believing that this three-pronged test applied in all circumstances, but it appears that, in fact, you have the discretion to grant the relief sought, and so we support staff in this matter.
Thank you, Mr. Randall. Ms. Iori?
Thank you, Chair Winslow and Commissioners. I do want to address this, quote, additional precedent that staff has found. We were quite well aware of those cases, but they are all distinguishable. First, excuse me, many of those are electric or energy efficiency or reduction of demand for electricity and natural gas, which our state legislature has decided is the policy of the state. The Delaware Energy Act specifically mandates deferred accounting treatment for energy efficiency expenditures that affected energy providers such as Chesapeake and Delaware incur in complying with the Act and which are not recovered through other means. But there is no statute that authorizes deferred accounting treatment for non-rate case related legal expenses, or for that matter, any legal expenses. Similarly, Delmarva's dynamic pricing and load control dockets arose from the enactment of the Energy Conservation and Efficiency Act of 2009. That codified the state's policy to reduce energy demand by requiring utilities to significantly reduce electricity consumption and demand. But there is no statute implementing any state policy goals relating to legal expenses incurred in between rate cases. Furthermore, the dynamic pricing docket and the regulatory asset treatment for bill reprogramming costs were both settled. As the Commission knows, in settlements, there are a lot of horses that get traded. There is no settlement here. With respect to the AMI program costs, Delmarva estimated that full AMI implementation would cost approximately $100 million, depending on system capability and configuration. This was at a time when Delmarva had $21.2 million of net operating income. The estimated AMI cost represented almost 5 times that net amount. Disallowing regulatory asset treatment would have had a significant impact on Delmarva's financial integrity and would have adversely affected its ability to provide safe and adequate service. It wasn't necessary for the Commission to say so in its order because it was so obvious from the circumstances. In our opposition to Artesian's request, we observed that the original requested amount of $227,000, which has been reduced now to, I think, somewhere around $178,000, represented 1.8% of Artesian's pro forma test period operating revenue in its most recent rate case. So these additional cases that staff has found all had much different circumstances surrounding them. Some, the Commission didn't have any discretion because state statute provides for regulatory asset treatment. In others, it was clear that if the Commission denied regulatory asset treatment, the utilities' financial integrity would be affected, and or its ability to provide safe and adequate service would be impaired. So we do not believe that those cases provide any basis for the Commission to reverse the decision that it made in December, and Artesian is not being held to a higher standard than any other utilities in those cases. And keep in mind, the Commission has set the standard. It is that the expenses are extraordinary and that they will impair, if they're not recovered, they will impair the financial integrity of the utility or impair its ability to provide safe and adequate service. Now, Artesian again argues that the Commission should incentivize utilities to protect their ratepayers. Artesian made this argument before the Commission during the oral argument on December 20th, and the Commission apparently was not persuaded by it then. It is no more persuasive now. As we noted at the oral argument, utilities should be taking steps to protect their ratepayers, and they should not expect some reward for it in the form of guaranteed recovery of expenses. Artesian also argues that allowing deferred accounting treatment does not guarantee that Artesian will recover those costs in a future rate case. But this argument ignores the Commission's recognition in the United Water case and in Delmarva cases that granting deferred accounting treatment is, quote, tantamount, end quote, to approving recovery. And that is because under the FASB, the Commission has to find that recovery is, quote, probable, end quote. The Commission rightly has been reluctant to prejudge such issues. Now, I'm sorry, but you'll have to hear my dulcet tones for a little longer.
No, please take your time.
Now, we agree that it is the Commission's decision whether to grant re-argument or not. We respectfully submit that you should not. In our responses to staff's petition, we set forth the considerations that courts use in determining whether to grant a motion for re-argument. Now, we realize that the Commission is not a court, but it is a quasi-judicial tribunal, and as such, the standards that courts use to decide such motions provide some guidance to the Commission. And those standards are, first, did the court overlook a controlling precedent or legal principles? Artesian and staff argue it did. We argue you did not. Second, did the court misapprehend the law or the facts in a manner that affected the outcome of the decision? Again, it seems that Artesian and staff argue that you did. We argue that you did not. Third, is the move-in simply repeating arguments that it made before? And finally, does the move-in assert new arguments? Because if it is simply repeating arguments that it made before, or it is asserting new arguments, those are improper to consider on a motion for re-argument. Neither staff's petition nor Artesian's response addressed the standards by which the Commission should consider staff's position. Much of the petition and Artesian's response repeat arguments that they made on December 20th, and which a majority of the commission rejected. Staff has asked the commission to, quote, re-examine the criteria required to establish a regulatory asset and find that Artesian met those criteria. This is a new argument and should be rejected on that basis alone, but in any event, the commission did examine its criteria when it decided the case in December and decided that it would continue to apply them. With respect to staff's and Artesian's complaints that it only had a limited amount of time to prepare to address the DPA's position, this too is a new argument and should be rejected on that basis alone. But the alleged lack of time to prepare is attributable to staff and Artesian, not the DPA. Staff sets the agenda for commission meetings. It could have postponed the matter to the following commission meeting to give parties time to provide written submissions to the commission. In fact, as we set forth in the exhibit, as we showed in the exhibits to our response to staff's position, we requested staff to do so. And to avoid prejudicing Artesian, we stated that we wouldn't claim that any legal costs incurred between December 20th and the date of the next hearing would be barred from recovery by the prohibition against retroactive rate making. Notwithstanding our offer, Artesian objected to postponement, and staff declined the DPA's request, saying that the commission could decide the matter after hearing oral argument from the parties. And that is what happened on December 20th. The commission heard oral argument. There was no evidentiary hearing because no witnesses were presented. It was all oral argument from the lawyers. Moreover, the DPA even provided staff and Artesian with two of the cases that it was relying on to support its position nearly 5 full days before the oral argument on December 20th. Surely that was enough time to read those cases and prepare to distinguish them or contend that the commission should change its treatment of regulatory assets requests. The DPA got the research done. Staff and Artesian could have done the same. Now, staff apparently contends that utilities should be made whole for certain costs that they incur between rate cases. This contention demonstrates a fundamental misunderstanding of rate making. The rate-making construct under which this commission sets rates is to grant a return on equity that exceeds the return that would be earned on a no or low-risk asset because of risks associated with equity securities. One of those risks is that the utility may incur costs between rate cases that they may not be able to recover. And that is what the commission recognized in order number 9039. Staff also argued that denying Artesian the opportunity to recover these costs places it in a catch-22. But the commission addressed that order in number 9039 when it observed that it grants utilities a return on equity to account for risks that they incur in their operations. And this is one of those risks. Circumstances change between rate cases. Expenses go up, expenses go down. For example, utilities routinely refinance debt in between rate cases to secure a lower interest rate. But the utility does not request a regulatory liability to capture the savings it achieves by those refinancings to apply them in the next rate case to benefit ratepayers. Instead, the commission determines the utility's cost of debt in that next rate case based on the interest rates then being charged to the utility. And that is proper because applying those savings in the next rate case would be retroactive rate making on the other side. Now, rate making is prospective, and in rejecting United Water's request for a regulatory asset in docket 96-164, this commission expressly recognized that the rate making procedure does not look to adjust for past losses or gains to either the utility or the consumers. Furthermore, the revenue requirement that this commission approved for Artesian in its most recent rate case includes an amount for a normalized amount for legal expenses unrelated to rate case costs. Sometimes that amount is more than the utility spends on such legal costs, and sometimes it's less. But that is the reason why we normalize these things. So nothing that staff for Artesian has argued now warrants the commission changing its decision. Now, staff also argued that the commission's ROE orders for utilities don't contain any factual evidence that the commission considers the risk to utilities when it awards them an ROE. This contention ignores basic finance. The fact that the ROE is higher than the cost of no or low-risk assets is itself a consideration of risk. The Commission is experienced in financial matters, and so you all know that there are two types of risk. Systematic risk, which is risk common to the particular utility industry, and unsystematic risk, which is risk that is unique to the particular utility itself. And when you award an ROE that exceeds the cost of debt, you are recognizing both types of risks and compensating the utility for those risks. So we contend that it is unfair to ratepayers to not only reward the utility for assuming certain risks by granting a higher ROE, like the risk that it may incur more legal costs than are reflected in its current cost of service, but then also require the ratepayers to pay for that risk dollar for dollar. Staff also argues that Artesian provided it with assistance in the emblem matter, and that it is inappropriate for the Commission to deny regulatory asset treatment for a case in which Artesian was, quote, ultimately exonerated of wrongdoing, end quote. First, Artesian made this argument to the Commission before, and I would refer you to pages 21 to 23 of the December 20th transcript for the assistance that Artesian allegedly provided, but the Commission was apparently unpersuaded. So this is simply a rehash of what Artesian already argued. Second, Emblem filed the complaint against Artesian, not staff. So Artesian would have fought Emblem regardless of whether staff was in the case. Whatever assistance Artesian provided was only because it was already in the case. It's not as if the complaint was filed against staff and Artesian then offered its assistance. Third, neither the hearing examiner nor the Commission, quote, exonerated, end quote, Artesian from anything, because the DPA never alleged that Artesian engaged in any wrongdoing, so this is a straw man. But we do observe that the hearing examiner found that Artesian's more than 2-year delay in notifying Emblem of its CIAC claim was, quote, unacceptable, end quote, and the Commission adopted that factual finding. We further observed that staff conceded at the Emblem hearing that a water utility should notify a developer when the utility knows what the CIAC cost will be. Had Artesian communicated the notice and CIAC costs to Emblem up front, the underlying litigation wouldn't have happened. In its response, Artesian put up a different straw man, rebuking the DPA for not having intervened in the underlying Emblem action and chastising it for intervening in this filing. But whether the DPA intervened in the complaint docket or not is irrelevant to the issue before you, which is whether you should grant re-argument on Artesian's petition to defer its Emblem legal costs for possible recovery in its next base rate case. Staff also argued that the Commission's decision in Order Number 9039 encourages utilities to minimize participation and related costs in complaint proceedings and encourages them to file limited issue rate cases. This is a new argument, but should the Commission be inclined to consider it, it's nothing more than conjecture. In its petition, staff told the Commission that the DPA doesn't like regulatory assets, and that's true. What is also true, although staff doesn't mention it, is that staff doesn't like limited issue rate cases, even though the Public Utilities Act expressly allows them in 26 Delaware Code Section 304B. Artesian says that limited issue rate cases are not in ratepayers' best interest, but that too is speculation on its part. That the General Assembly specifically provided for limited issue rate cases reflects a determination that such cases may well be in ratepayers' best interests. Artesian also argues that utilities would be discouraged from taking positions that would benefit their ratepayers if they cannot recover all of their legal costs. This, too, is a repetition of an argument that Artesian made on December 20th. The Commission acknowledged in its order that Artesian had made this order, but did not explicitly address it. Apparently, the Commission did not find it persuasive the first time around, and we suggest that it is no more persuasive here either. Staff argues that the regulatory asset treatment should be allowed because the expenses were extraordinary, but the Commission, in an order number 9039, assumed for purposes of its decision that the expenses were extraordinary, so the Commission already determined the very thing that staff wants it to determine now. Staff next argues that FASB's guidance on regulatory assets does not require a threat to a utility's financial integrity or delivery of safe and effective service. This is no surprise. We did not suggest that FASB guidance did require that. The DPA made it clear that it was arguing that the Commission has applied a standard in previous cases that regulatory assets will be granted sparingly and only when the utility's financial integrity or ability to provide safe and effective service is jeopardized. Staff also says that FASB's guidance requires a high probability that the deferred expense will be recoverable in future rates. We agree, and that is the heart and soul of our objection. And that is what the Commission has recognized is tantamount to pre-approving recovery. The Commission simply applied its long-standing standards for the considerations of requests for deferred accounting in this case. Staff contends that the cases the DPA cited contain no discussion of timing and probable rate recovery, but that is not correct. In the United Water case, Order 7838, the Commission specifically stated in paragraph 23 that allowing deferred accounting treatment is tantamount to assuring future recovery, and that is why it is reluctant to create regulatory assets. The Commission also said in paragraph 13 that creating regulatory assets, quote, challenges the matching principle, which normally seeks to ensure a matched review of both costs and revenues for an identified period of time. Last, staff argues that Artesian's request satisfies the matching principle because the benefits of the expenditure closely match the timing of its recovery from ratepayers. Staff didn't make this argument the first time, so the Commission should disregard it. But if the Commission is inclined to consider it, it is incorrect as a matter of law. The costs have already been incurred, and whatever benefit ratepayers got from them has already accrued. But recovery will come later, after the next time this Commission sets rates for Artesian, whenever that may be. And the Commission recognized this mismatch in the United Water case. So in conclusion, the DPA respectfully suggests that neither staff nor Artesian has provided the Commission with any persuasive reasons to reconsider its earlier decision. The Commission did not misapprehend the law or the facts. It did not overlook controlling precedent or legal principles. They have simply reiterated the same arguments that they made when the Commission originally considered Artesian's position. Now, this Commission has held that the rate-setting process provides no guarantee that a utility will recover all of its actual expenses from ratepayers. But that is what Artesian seeks to do in its position, and that will be the result if the Commission reverses its decision. We respectfully request the Commission to deny staff's petition for re-argument. If the Commission grants the petition for re-argument, then the DPA respectfully requests the Commission to reject staff's and Artesian's argument and conclude that its original decision stands. We appreciate the Commission's consideration and attention. Thank you very much.
Thank you, Ms. Iori. We have a very, very short rebuttal.
May I?
Yes, sir.
Just very quickly. Thank you, Chair Winslow and Commissioners. One glaring problem with the public advocate's statements, it all surround a motion for re-argument and the standards there. That is not the standard. If it were, and this Commission were to look at whether precedent was overlooked, clearly it was not, because Mr. Randall pointed out, we have submitted this precedent since. Whether Ms. Iori saw that precedent before, took it into consideration, found it distinguishable, that may be, but it wasn't in the papers. So that's not something that was considered. And if you're going to overlook the law or facts, again, not having that precedent covers that as well. And third basis with repeating arguments. Again, you're not repeating an argument. This is a different argument. We have put the FASB standard there, and that is something we respectfully submit that the Commission should consider and not have this denial of a regulatory asset in a vacuum of the showing of a financial integrity landslide. It is more than that. It is an extraordinary circumstance. This has never happened before. That bespeaks extraordinary circumstance. Extraordinary is something that's unusual to the circumstances. Clearly, that's the case here. And it wasn't considered fully and under the proper standards. Thank you.
Mr. Randall?
Just a couple of points, Your Honors. Firstly, getting to the timeline for when everything happened, there was the comment that she had sent an email citing a couple of cases 5 days before the argument. At that December 20th hearing, staff, Artesian, and Emblem were preparing for argument on the heart of the matter, which was who was going to pay the expenses associated with that infrastructure. Artesian's petition for a regulatory asset, while important to Artesian, was the tail and not the dog. And having to cite everything quoted in the brief that we received the day before argument was burdensome and not something we could adequately do. There was also the comment that there could not be any prejudice to Artesian because the public advocate offered not to contend in January that expenses we incurred between December and January were barred by retroactive rate making. I invite you to read Ms. Iori's email from December 15th, where she clearly states that they believed all of the expenses incurred up to October 20th were barred, and yet somehow the expenses incurred after the underlying proceeding was resolved, they wouldn't object. We do not understand our obligations to this commission to be limited to we'll wink and look the other way. If we're barred from the relief we're seeking, we would bring that to the commission's attention, regardless of what the public advocate does. If we wanted the relief that we were seeking, we needed it on December 20th before Emblem was done. Ms. Iori has stated several times that Artesian is seeking guaranteed recovery. Those are not words that should be put in my mouth or my clients. Both in December and today, what I have said is getting deferred regulatory asset treatment would be the first step in a two-step process, and when we come in for rates, you would have the opportunity to decide whether it is just and reasonable to allow that recovery. She cites the standard. The standard is under FASB whether it is probable that we would be able to recover. That's merely more likely than not, the 51% of proof. Now, that there is a commission precedent saying tantamount, but clearly these are expenses that are going to be contested and scrutinized. We have heard the commission. We are not seeking a guaranteed recovery. We are seeking the potential for recovery. And the last point, we believe that staff is correct. There are perverse incentives set up because of the precedent that the commission entered that impact all utilities. If you were to grant the deferred regulatory asset treatment here, then when other utilities go out, and we're not seeking recovery of all expenses between our rate cases, we don't file these petitions frivolously for every expense that we incur. As was noted in staff's brief, the expense that we incurred for the Emblem proceeding, even at the accurate level of approximately $178,000, is nearly $60,000 more than was granted in our legal expense encompassed in rates, and that's on top of an entire normal year's legal expense because this proceeding was outside the box. This isn't what we do day in and day out. We don't have proceedings like that complaint proceeding every year. That was the first time in the decade since the Commission had enacted the SIAC regulations that there had been a disputed proceeding on those. So what is at issue was an extraordinary amount of expense. We believe that it would serve all utilities to at least have the ability to recover, so there's less appetite for limited proceeding rate cases, which could be just as expensive as the litigation against to protect the ratepayers. For those reasons, we believe that staff's motion for re-argument should be granted.
Thank you, Mr. Randall.
Brief rebuttal,
You've already,
Chair.
no, not today.
1 minute? I can do it in 1 minute. You know I can talk fast.
Okay, go ahead.
Staff counsel said that the standard that we cited for granting motions for re-argument is not the standard, but it did not provide what the standard is in its opinion. Second, staff says this has never happened before. The issue is whether litigation costs are incurred in between rate cases. I can't believe that that has never happened before. What has never happened before is that a utility has come in and asked to create a regulatory asset for them. Third, the fact that Artesian was preparing for another argument and couldn't adequately prepare, that happens with lawyers all the time. There are many times when we have more than one thing going on before this commission that we have to prepare for. Up to October 20th, those expenses were already occurred, so we weren't going to give that up. Finally, the first step in a two-step process, it ignores that the recovery is probable. Probable does mean more likely than not. Thank you.
It's under 1 minute.
Told you I could do it.
Here's our worry. In your research, did you find anywhere around this great country any like case that you could recite to me?
I did not look for cases in any other jurisdiction, Mr. Chair, because we thought that the Commission has been clear in its determinations of when it will grant a regulatory asset.
The three-pronged legal argument that you argued in this case was first heard.
That was, I'm sorry?
The three-pronged legal argument that you made when this case was before us before.
Yes, that was this Commission's orders.
Correct.
Yes.
Thank you. Any questions, commissioners?
Yes, Ms. I yield.
Commissioner Correa.
Thank you. A couple of items to understand the other side of the story about being financial stress or distress for the company, and also helping me to understand rehearing and or reconsideration. As of today, if I look at your balance sheet, where is this amount, $178,000? Where does it sit? And what is the title? Is it called deferred assets? What is it called?
May I defer to the Chief Financial Officer of the company, Mr. David Spate?
As the matter was decided in December, our auditors required us to write those amounts off at the time because they were not deemed recoverable because this commission denied it. So they were written off against the income and then subsequently reduced retained earnings. So that's how it kind of flows.
That was 2016 income, about 80 million, 79, 80 million dollars.
Right. Because we are public reporting, those things are required to be written off when the commission makes their ruling.
Sure.
This is a re-argument, so those could be reversed and put back on the balance sheet according to the commission's order, which would increase or decrease expense, but then become a deferred expense that then would be written off. It's all according to the commission's ruling.
Sure.
Commissioner Correa and all the other commissioners, I would respectfully submit that what we should decide first is whether or not we're going to approve the request for reconsideration. If we're not going to, all this discussion about the balance sheet and other questions are really just sort of a waste of our time. So I will ask that for now we limit our questions with respect to the issue of whether or not the state should be granted a rehearing. And then we can decide to do as Ms. Iori suggested, or other people will have ideas afterwards as well.
I think that was helping me to make a decision on rehearing or no rehearing. So,
Mr. Gray?
Thank you, Mr. Chair. And Mr. Randall, this question probably goes back to Artesian's handling of the Chester Water Company's legal expenses. How did Artesian handle those expenses? Just to give me a context as I think about rehearing in this case.
I think that the resolution of our rate case was one of the first proceedings that many of these commissioners had. The Chester Water litigation expense ultimately fell into kind of two buckets. There was approximately $800,000 of expense that we incurred before the test year. There was approximately $800,000 worth of expense that was incurred during the test year and test period. Because the expense was ongoing, we were denied recovery of what was incurred before the test year because we had not sought deferred regulatory asset treatment of it. We were allowed recovery of the $800,000 worth of expense that was incurred during the test year and test period as a separate item beyond the level of litigation expense that was also included in rates. Have I stated that correctly, Dave? Yeah.
So I understand from your answer what the commission decisions were. What did Artesian do? How did you book what you were not allowed? Thank you.
All right. The expenses pre-test period were expensed. They were written off currently. We had accrued a number of expenses, so those were written off in those periods prior to the case. Once we had requested recovery of those expenses, they were then deferred, and upon adjudication in the case, those then are being amortized over the period of time, and I don't remember the exact period of time they're being amortized over, but they're being amortized over, I believe it's the remaining extent of the contract.
Okay.
Number of years of the contract.
That pretty much answers my question. Thank you. No further questions, Mr. Chair.
Well, thanks to everyone for all their arguments and all the work that they did on the briefs. I confess that when I was here and hearing the case, that I had some really bad feelings about ruling against Artesian, primarily because of the fact that they took up an issue that they didn't have to take up, and I was concerned about the argument that the staff made that incentivizing utilities in general to protect from those sort of situations was basically a good idea. I'm not saying that any more than that. I'm just saying that it sounds like maybe better public policy to incentivize a utility to protect the ratepayers than it would be to have them ignore the ratepayers and just let the expense go through uncontested. And when I sat here, I frankly felt very constrained by the legal arguments made with respect to the three-pronged test and the prior commitments of this commission. I felt duty-bound to follow them. And I do believe, had I had the opportunity to hear some of the additional precedents, admittedly, not necessarily, and I understand, and I've heard Ms. Iori's arguments on each one of them, and I've read her well-written comments on each one of them. But I do feel that had I heard more of the underlying facts and precedents, that there's a possibility, not a probability, but a possibility that something different may have happened in our case. And I myself, I'm going to vote for staff's petition to reconsider this matter. And I think that 99% of what Ms. Iori said is, with respect to precedents, is true. In other words, we've said what we said about being reluctant to make deferred assets. I believe that what Mr. Randall says is correct, too, that this is no guarantee. I think the public advocate makes really strong arguments about this particular issue, but I'm going to support rehearing on this matter for the reasons I've stated and for the reasons set forth by Mr. Randall and Mr. Walsh in defense of their respective positions. Anybody else wish to talk about how they feel in this situation?
You're feeling emotion?
Mr. Chair?
I'm feeling emotion, yes.
Right, so while you organize your motion, I'll take just 30 seconds. I think it would be beneficial in a rehearing context to consider the parameters that should drive an informed decision from the Commission. On the other hand, as I sit and think about the previous case with the Chester Water Company and the substantial dollar amounts that were involved in those cases and the outcome, and I try to quantify in this particular situation as I read through the materials, there's more or less a net $60,000 of legal expense above and beyond what I have read as $117,000 that nominally was available in the last rate case on an annual basis for legal fees. Now that doesn't say you don't have other legal fees other than this particular case. But the sheer dollar numbers of $60,000 over the performance numbers in your balance sheet and your P&L seem rather small. So on that basis, it leaves me kind of on the fence, but I just wanted to express from my perspective that it will be helpful for the Commission to gather more insight on the parameters that drive a good decision.
I understand what you're saying, Commissioner Gray. I would just point out that I think it's the legal principles here that are more important than the dollar figures.
Yep.
In other words, are we going to set up a deferred asset, and should there be new standards? Should we change the standards from before? Should we have those three? Should those three standards remain? Should there be other circumstances that would warrant a positive deferral? So I mean, there's a lot of. I think it's not the amount of controversy; it's the principle of the controversy.
I'm prepared to second your motion, Mr. Chair.
Well, you're welcome to do so then.
I haven't heard one.
You second it?
Well, you haven't articulated it yet.
Well, I move that the state's motions for reconsideration be approved.
I second.
Any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Now, that's not the end of it. As I already mentioned, a possible way to dispose of the case, which is for us just to make the same decision we made last time. But having said what I've already said, which was I was uncomfortable with how I voted last time for the reasons I stated, I'm very uncomfortable going forward. And of course, I think Commissioner Gray has indicated, that now after this discussion, we'd like to hear some more. So the issue in my mind is whether or not, and I want to address this to Ms. Iori because I think she's the best person to answer this question. My question would be, what would be the best process to make sure that when this issue comes to us, we make a good decision on behalf of the state? Should we get a hearing examiner involved? Should we just come back to the commission? What is your thinking on this? I mean, I don't know.
Well, it's really a legal issue. There really aren't any factual disputes, I don't think. I mean, Artesian has conceded that this is not going to have a huge effect on it financially. It's already written it off. Now, I know it was required to, but it's already written it off, and you don't hear them saying that this had any kind of adverse financial effect on them. So I think it's really purely a legal decision. Should the commission change a standard that it has applied pretty consistently in contested cases for at least 20 years since the United Water decision in 1996?
Thank you very much.
I just think I should point out that the order that we're talking about from October 16th, the order number 9039, The vote on that order was actually 3-1. Ms. Drexler abstained and Commissioner Winslow voted no on the order. And the other 3 commissioners voted in favor of this decision that we're now going to have a rehearing on.
Well, meaning that this came up a little unusually. The public advocate objected to the form of order. So the 3-1 vote meant that Commissioners Gray and Conaway and Correa voted not to approve the petition because the form of order that was presented to you was approving Artesian's petition. So Chair Winslow voted to approve Artesian's petition.
Chair Winslow?
Yes.
You asked Ms. Iori for guidance. If you were to look to fashion the relief that you have in mind here based on the concerns you've expressed, I would limit perhaps there should be an exception for creating a deferred regulatory asset if it is an action that is taken solely to protect the utility's ratepayers. If a utility were to claim it was incurring expense, whether it's legal expense or otherwise, for that reason, and you were to ultimately conclude that the utility was wrong, they're not going to be allowed to recover. If they are incurring reasonable expense to protect ratepayers, then they could have the opportunity to have deferred regulatory asset treatment, and you could consider the level of expense that they incurred in their next rate case. That way you serve the public policy and you get to the correct legal result in the end.
With all due respect, your commissioners, what utility is going to say that they weren't doing what action they took to protect ratepayers? That opens the floodgates. It doesn't matter.
Okay.
Solely.
I was just asking about process, not a lot of pre-arguments on the issues. So I guess the bottom line is that it seems to be the consensus around the table that we should just take it on and decide it sometime in the near future. So any other commissioners have any comments on that or any observations or any different approach you want to put on the table? Okay, so with Mr. Walsh, with Ms. Iori, and Mr. Randall, you need any other motion, or will this just come up next time, in the next calendar, or the next? How much time do the parties want?
Well, I'm not sure what you're asking.
Well, I guess what I'm thinking to myself is if it's a purely up and down with respect to the deferred asset based upon what I've heard so far, I mean, we can do that. Obviously, we can do that.
I believe that's what the commission should do.
Okay.
I don't think there's going to be any additional guidance from any additional materials we could submit.
Okay, so you don't think anyone like the staff or anyone like Mr. Randall is going to suggest any changes to the present legal standing?
No, I think they would, but you've heard what they've suggested. You've heard staff suggest that it should be a case-by-case basis. You've heard Mr. Randall suggest that the standard should be if it's solely taken to protect ratepayers. And our suggestion is that it should be what the commission has done for the past 20 years.
Okay,
I would note that if the commission does change the standard, it does need to explicitly explain why it is reversing itself, so that the court that will hear an appeal can understand why the commission took what the action that it did.
Chair Winslow, I think an easy way to streamline this, as is sometimes done in the courts, something at this procedural posture, parties can submit 10-page letter brief, or I don't think it would need to be more than that. At the same time, there's no rebuttal. Our arguments are there, and the commission can then hear arguments, or if it, in its discretion, decides it doesn't need to hear arguments, and present it in 10 pages. There's no 11th hour filings. There's no misconstruing of arguments. That makes it very cut and clean, and each side can be the proponent of what it believes is a proper test.
Because Lori's already written 20 pages. I'm not sure if she could write it.
Well, that's
Chair
why
Winslow, I was just going to say, with all due respect, we've addressed this twice. They've already addressed it. I'm not sure what good the prolonging the agony will. I mean, if the commission wants to reverse itself, we will live with that. We'll appeal it, but we'll live with it. But we think the commission should make a decision.
Well, I don't. I obviously agree with that.
If I may, Ms. Iori asked what the good is in it, and I would simply state that a lot of trials are won in closing argument, because you have to summarize, you have to get to the point, you have to be short and sweet and get out, and that's where we are now.
With all due respect, we were already there.
Chair Winslow, you made a comment about seeing how other states have handled this. I'm not sure that any party has looked to see whether similar circumstances have come up elsewhere. And if you were to defer the decision passed today, one of the things we could do is look to see if other commissions have had to address similar circumstances. For whatever weight you wanted to give it.
The state does not have access to the public utilities reports, so we will be at a disadvantage unless a court has ruled on that issue.
Well, I think we should just schedule it for the next meeting and get it all done with. However, if there is in fact any legal precedents that could be, just share it. When's the next, 14th of September? How about the Friday, if you're going to do any research and come up with any cases that you want us to consider, to exchange those the Friday before the meeting? I'm sorry, the Monday before the meeting. That'll give the parties 3 days to read the cases and come up with any arguments that you need to. And that way, if there's something out there that would help us with respect to thinking about this particular issue, it may be that there's no way to help the utility based upon the facts of the law, but I think we should at least think about it. Okay, that's the way it is, I guess. Mr. Howell, is that okay?
Doesn't there need to be a motion?
Well, probably, I guess. If you want a motion, I'll make the motion that we hear this matter on the agenda September 14th, that the parties are permitted to do any legal research on any other cases with respect to this issue and submit them to each other the Monday prior to the Thursday meeting, and that we'll hear a final argument on the 14th, which will be abbreviated, and we'll make a decision.
Second.
Any more discussion on the motion? Hearing none, all in favor signify by saying aye. Aye. Any opposed? Any abstentions? The motion carries. Okay. Thanks, everybody. Number 4 is in the matter of the adoption of rules and regulations relating to the creation of a competitive market for retail electric supply service. Proposed order 9104. Ms. Scott.
Thank you, Chair Winslow and Commissioners. Delmarva Power filed a request for a waiver with respect to the implementation of one of the provisions of the electric supplier rules, which were adopted by the Commission in February of this year and ultimately were implemented on April 11th, 2017. Specifically, the rule in question has to do with accelerated switching. We have a small subset of customers for which we need to make some significant changes in our billing systems to be able to accommodate this. We are currently making those changes with respect to our Maryland customers, And we would like to get that process completed and out of the way to then be able to do the same for our Delaware customers. So we have requested, pursuant to the provisions of the rules, we've requested an additional 6-month time frame to be able to do this with respect to approximately 3,300 customers of Delmarva's. I had discussed this with staff, the DPA, as well as RISA, who had all been involved, very actively involved in the changes in Reg Docket 49, and none of them had expressed any opposition to our request. The form of order grants the request. We have no issues with the form of order, and we ask that you would approve it.
Thank you, Ms. Scott. Mr. Geddes?
Mr. Chairman, members of the commission, Ms. Davis prepared a memorandum dated August 10th, 2017, which states staff's position with regard to this. In addition, she drafted the order. And so I would suggest if you have any questions with regard to this and staff's position, we ask Ms. Davis, because I have absolutely nothing to do with it.
Any
But
questions?
we support that. We support them.
Is there already any comment?
No, we support the form of order.
Any questions, commissioners?
Move we adopt order number 9104.
Second.
Any discussion on the motion to approve proposed order 9104? Hearing none, all in favor signify by saying aye. Aye. Any opposed? Any abstentions? Motion passes. Thank you, Ms. Scott.
Thank you.
Now we have Chesapeake Utilities. I believe Mr. Denman's present. Welcome, Mr. Denman.
Good afternoon, Commissioners.
Who's the person to your left?
This is Thomas Mann. He's the Vice President and Treasurer of Chesapeake Utilities Corporation.
Welcome, Mr. Mann.
Thank you.
He's here today to answer any specific questions you may have with respect to the application. In this application, Chesapeake is seeking the Commission's approval to issue up to $100 million in unsecured long-term debt and $200 million in common stock. These issuance would take place potentially within the next 2 years, if not sooner. Any additional debt that would be issued would be balanced with the amount of common stock that's outstanding in order for the company to achieve its target debt equity ratio. Any proposed issuance would be consistent with the company's debt covenants, which restricts its ability to issue debt in excess of, I believe, 65% of its total capital. If the company issued all of the debt and the common stock that it's requesting, the resulting debt ratio would be 52.4% with the balance in equity. So it would still be within that debt equity ratio. The purpose of this debt and stock would be to finance capital additions, satisfy working capital requirements. Some of the debt would probably be used to retire short-term debt. Most of the capital expenditures are for improvements in its regulatory assets. Joseph DeLosa submitted a detailed memorandum to the Commission outlining the company's application, and we agree with the factual accuracy of what's in that memorandum. And he's recommending approval of the application subject to the conditions set forth therein. And the company, of course, supports the staff and is willing to comply with those conditions. We've reviewed proposed order number 9107, which would approve the application and set the conditions, and we would urge the Commission to support it. The anticipated interest rate on the debt, being conservative, would be in the neighborhood of 5%, but in actuality would probably be less than that. So this is a good time for the company to be issuing debt. The interest rates, as you know, have been relatively low, and the company, of course, wants to take advantage of that. Mr. Mann is here to answer any questions or provide you any feedback that you have, but that's basically all I have to say.
Thank you, Mr. Denman. Mr. Walsh?
Thank you, Chair Winslow and Commissioners. Mr. Denman, read just about everything I have on this matter. I concur with everything that was stated in terms of the numbers, the percentage that was represented. The current debt covenants having been met. I know that Mr. DeLosa reviewed this, and Mr. Smith is here today, who also reviewed this. And we are satisfied that it meets all the requirements under Section 215, and we request that the Commission approve this order.
Thank you, Mr. Walsh. Mr. Slater, Ms. Iori, any?
The public advocate did not intervene in this proceeding.
Commissioners, any questions? Mr. Correa has one.
Your ratio, debt to equity or equity to debt ratio, 50 to 48, is very good. Very, very good ratio. And for utility, it's really, really a positive ratio. A couple of items I have for you, General, is you have a short-term borrowing of $146 million reported on your K8 to Commission. I mean, not this Commission, the Security and Exchange Commission. Even if you borrow $100 million and make it a long term, you still have $45 million short-term debt. It's a good idea to convert the short-term into long-term and save some lot of money on the interest rate and what have you. Do you have any short-term plan to reduce that $45 million and pay off or what?
Yeah, I mean, I think we would try to match the asset lives with the liability maturities. So, yes, I mean, we regularly look at our balance sheet in support of, the strength of our permanent capital.
And that also affects your PE ratio, which is 31. And PE ratio, you could get the stock market a couple of days ago. It's a very good ratio. And again, I'm very impressed with your 50 to 48 equity, debt to equity ratio and equity to debt ratio. So I like your balance sheet. I have looked at it, and I also looked at K8 a couple of days ago. Yeah. And I think that's a very good approach, very good financial management, and I plan to support your application.
Thank you.
Thank you.
You want to make the motion?
What?
You want to make the motion?
Oh, yes, I'll make a motion that we adopt. Is it 9107?
Yes, sir.
Right?
I second that.
Is there any discussion on Commissioner Correa's motion to approve order number 9107? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstention? The motion carries. Thank you, Mr. Denman. Mr.
Thank you,
Mann,
Commissioners.
Thank you, gentlemen.
Mr. Walsh, and Commissioner Correa. Number 6, in the matter of the application of Delmarva Power and Light Company, increase in electric base rates and miscellaneous tariff changes. I don't see Representative Walco in the audience.
I think I'm representing him.
Mr. Goodman?
Thank you, Chair Winslow, Commissioners. Todd Goodman, as you know, here on behalf of Delmarva Power. And I think there's actually a proposed form of order before you that, as usual, your staff took made the effort to get the draft out and shared it with not only Delmarva but DPA, and Gina, as she always does, played the English grammar professor and polished it up nicely. And so we have an agreed upon order that opens up this docket before you that we thank Mr. Geddes and Ms. Iori for helping put together.
Mr. Geddes.
Mr. Chairman, I won't respond to Mr. Goodman's comments, but I will say that this is a normal opening order, which appoints a hearing examiner and also approves public notice. I apologize on behalf of the parties that we were not able to get this to you earlier, but the filing, as you can see from the first paragraph, was last week. And I do think this might be a record in terms of getting an open order before the commission based on a filing date that occurred 3 business days ago, 4 business days. There are 2 provisions in this I'd like to point out to you which are different than the normal opening orders. One is paragraph 5, where staff has requested additional time to review the application. because we have not had a chance to review it for compliance with minimum filing requirements. And the dates set forth there are in compliance with the rules. So it gives us 15 days to review it and the company 15 days to respond to it. The other provision, which is one actually Ms. Mouchar made sure that we put in the public notice, is paragraph 9, where we have decided in this particular case not to wait for the intervention period before getting discovery and getting the case started. So there's a provision here that says any intervention, if received and granted, will take the case as it exists. So if there's discovery ongoing, the interveners cannot suggest that they get to start all over. They'll have to take the case as they find it, because it is going to start as soon as you sign this order, assuming you sign it. Anyway, staff supports the form of order and appreciates all the parties' help in coming to a consensus on it.
Thank you, Mr. Geddes. Any questions, commissioners? If not,
Chair Winslow.
Oh, I'm sorry, Ms.
I know
It
you're tired.
It must have been psychological.
I know you're tired of hearing from me. I'm tired of hearing myself. The public advocate will be filing its statutory notice of intervention in this case tomorrow. We do support the form of order. I do want to point out, however, that it was not Ms. Moucher's idea solely by herself to provide for interveners taking the case as they find it. That was a provision that staff and Delmarva and the DPA all agreed to.
That's not what I said.
Okay, thank you, Ms. Ivory.
Putting it in the public notice.
Are there any questions in the parties?
Move we adopt order number 9108.
I second.
Any discussion? Hearing none, all in favor? Aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, everyone.
Thank you.
Number 7, in the matter of the application of Delmarva Power and Light Company for an increase in natural gas base rates. Proposal order 9109. Ms. Scott.
Thank you, Chair Winslow and Commissioners. This order to open the base rate case docket for gas is virtually identical to the one you just approved for the electric case. It establishes the intervention deadline. It includes the same language that Mr. Geddes just pointed out to you with respect to meeting the requirements for the minimum filing requirements and responding thereto, as well as for intervention purposes that the parties take the record as they find it. We would ask that the order as submitted be approved.
Thank you, Ms. Scott. Mr. Walsh.
Chair Winslow and Commissioners, only to point out the same paragraphs and to thank everybody for their consolidated effort in getting this done quickly. The Commission will approve this order as submitted.
Thank you, Mr. Walsh. Ms. Iori.
Thank you, Chair Winslow, the public advocate, and will file its statutory notice of intervention in this case tomorrow. We support the proposed form of order.
Thank you. Questions, Commissioners?
Motion we adopt order number 9109.
Second.
Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Is there anyone here from the public that wishes to make comment to the Public Service Commission? Mr. Howitt.
Chairman Winslow, Commissioners, I thank you very much for the opportunity to comment. As you will note on the agenda, staff had planned to discuss the latest settlement developments on FERC rate case docket number ER 17419. But unfortunately, some last-minute proposed changes among the parties is going to preclude our discussion at this time. So all I can ask is that you stay tuned, and we will probably be back to the Commission to discuss this case further when and if some of the issues can be resolved. The other things I would like to make note for you, there is an evidentiary hearing that is scheduled on the Suez Water Delaware Phase 2 cost allocation. It's scheduled for Tuesday, August the 29th, starting at 10 a.m. in the third floor conference room of the Carville State Office Building in Wilmington, Delaware. And lastly, I would make note that our next Commission meeting meeting is on Thursday, September the 14th, again, starting at 1 p.m. in our Dover office.
Thank you, Mr. Hallett. Safe trip home, everyone. We're adjourned.
Somebody just said that they're real. I like that thing.
So yes, probably a good idea.
All I said was
Suggested that.
no, I just said that she's just.
Yeah, say.
Gloria, Gina.
How was the city of Gloria?
Very good.
That's not the order in which it was,
Conway made it.
How are you? Good. How are you, lady?